So welcome everyone. Welcome to what is an LLB undergraduate classroom in Commonwealth Caribbean Human Rights Law, which is a compulsory course since 2006 for all persons who graduate with an LLB degree from the University of the West Indies at Cayville, St. Augustine, or Mona. I co-teach this course with Gabrielle Elliott Williams, who in a past life was on the winning team for the World Human Rights Moot Competition in Pretoria. And you probably, for those who are not students here, know Gabrielle as well. I'm delighted today to have the opportunity to have Fergus MacKay with us, sharing about this and other cases. He, of course, litigated this case and many others. He's senior counsel at the UK-based NGO, the Forest Peoples Programme, and he has been working in the Caribbean since 1995, when he was the legal advisor for the World Council of Indigenous Peoples. He's litigated several cases before UN treaty bodies, the ILO, the Inter-American Commission, and the Inter-American Court of Human Rights, including the important 2007 Saramaca Case, and the Kaliña and Lokono Peoples case of 2015, which the court did an on-site visit to Suriname prior to making its decision. He also served as an expert advisor to the OAS concerning the American Declaration on the Rights of Indigenous Peoples, and as a member of the advisory panel to the World Bank's Extractive Industries Review. He's the author of more than 60 books and articles on the rights of Indigenous and tribal peoples. He is the best expert you could have in thinking about these questions in the Inter-American system. And he plans in his lecture to begin with a discussion on the cases, and then to say a little bit about what's in a name and the names which are used in international human rights law before thinking about strategic litigation. Join me in welcoming Fergus, and very much looking forward to what he has to say. Over to you, Fergus.
Many thanks, Tracy. I'm very honored to be amongst such a distinguished group. So I'm going to briefly go over the three Suriname cases, and then a case from Colombia and a case from Brazil, which hasn't been decided yet. In fact, it was just submitted in the last couple of weeks. So the first case that was decided is called Alabutu et al. Versus Suriname. Alabutu et al. Were seven Saramaka men who were extrajudicially executed by the Suriname army in the 1988, I believe it was. I'm not sure the exact date. The case is important, not really because of the jurisprudence. The case is important for two reasons, apart from being the first one involving Maroons, of course. So the two reasons are these. One, the court was asked to decide whether Suriname civil law should apply or Saramaka customary law should apply to determining who were the descendants of the seven men who were killed for the purposes of reparations. Maroons are polygamous, Saramaka are polygamous, and if you added up the descendants according to Saramaka customary law, you'd need more than 2 hands and 2 feet. Whereas under Suriname civil law, they would essentially have one wife each, and only the children of that wife would be considered descendants. So the court ultimately decided that it should be Saramaka customary law that determines who are members of those men's families and who are their descendants rather than Suriname civil law. I have sat in a room where some women got very angry about this, and I felt like I should be quiet and not say anything, but I actually find it a very useful principle in dealing with lots of different issues. And it's really the first time in the Inter-American system, at least within the court, that they were forced to grapple with issues like that And I think ultimately they decided it the right way for reasons we can go into later. The other reason that case is important is, well, okay, let me come back to that in a minute. So no, let me do it now. The other reason it's important is they looked at a treaty between the Saramaka and the Dutch from 1762. The Saramaka had essentially argued that they were sovereign, independent nation on the basis of this treaty relationship with the Dutch, and therefore reparations should include collective reparations for the incursion of the Suriname military into their territory without the permission of their traditional authorities. The court really didn't like this one at all, for a number of reasons. It didn't get into whether Saramaka were sovereign or anything like it. It basically said, even if that's what your treaty does say, we will not take cognizance of that treaty in a human rights court because it violates Jus Cogens norms. In particular, the Jus Cogens norms were the requirement in the treaty that the Saramaka return escaped slaves back to the plantations, back to their Dutch quote unquote owners at the time. The court said, we will not countenance any instrument that provides for the capture and return of slaves. I understand the treaties in Jamaica have similar provisions in them. So I think if you were to try and go that way with those treaties, you'd run into that same problem. Now, it is possible under Vienna Convention on the Law of Treaties to separate out provisions that conflict with subsequently developed Jus Cogens norms. But they didn't get into that in the court. They just chucked it out basically and said that we won't even talk about this and we won't look at it and we're not going to. Later on in the Saramaka People case, they didn't reject the treaty. They just didn't use it in thinking about the merits of the case. They used it though as part of the facts. So they used it in the sense that the Saramaka had a right in the treaty to harvest and trade timber from their territory. In fact, the Saramaka were famous into the 1950s for transporting wood on the river and selling timber on the coast. And the court used that as part of the factual basis for deciding that the Saramaka owned the forests within their territory, because the state had argued that even if they own the land, they don't own any natural resources or the forests or the water or the air. So basically they own the land and nothing else. The court rejected that notion and partly based on the treaty itself, confirmed that the Saramaka owned the forest within their territory. It didn't, however, go that way with subsoil resources, gold, for instance. The Saramaka had argued that they owned the gold as well. And the court didn't say no to it. They just said the test is going to be, did you traditionally use that resource? And if you didn't, it's not within the ambit of your natural resource rights, according to us, right? So that's really Alabutu. It's kind of a very minor case. A long time ago. It was 1993. It's one of the first judgments of the court, in fact. That was followed in 2005 by another case called Moiwana Village versus Suriname. Moiwana Village revolves around a massacre of Aukana Maroons and Juka Maroons from obviously a village called Moiwana. Which occurred during the so-called Interior War in Suriname, which was 1986 until the 1990, almost 91. In fact, it was concluded in 92. So in Moiwana, the National Army of Suriname essentially killed 39 Aukana Maroons and did nothing. The state itself did nothing whatsoever to investigate this. To punish anybody who committed it, even though the intellectual author went on the news and said, I ordered it, and if you don't like it, come talk to me. So it was rather clear who where the responsibility lay. That case is important for two reasons as well. The first one is, in that case, the court decided that Maroons in Suriname are tribal peoples. I'll explain in the next section what tribal peoples means and where it comes from and all of that. But what it essentially did there was say that Maroons, as tribal peoples, basically have the same rights as Indigenous peoples. That had never happened before in the Inter-American system or anywhere else that I was aware of. And it very much changed the dynamic. If you're, for instance, a Maroon from Jamaica, and you can stand the term tribal people, it provides a shortcut to a set of rights that you would not otherwise be able to access as, for instance, a minority or a Afro-descendant collective, although there's perhaps some doubt about the latter, but we'll come back to that in a minute. The other important part of the Moiwana case was, again, the recognition of Maroon customary law for determining not just reparations, but also the substantive violations and the impact of those violations, but also the ongoing ownership of Maroon lands, even though no one had lived there from 1986 until 2005 when the case was decided. The court ruled that as a tribal people and as people who had deep fundamental ties to their ancestral lands, deep spiritual ties to their ancestral lands, that they had both an ongoing right to reclaim ownership of those lands and an ongoing right to return to those lands. And Suriname was responsible for those violations in part because it failed to investigate the massacre. So these people, most of whom were living in French Guiana, had no idea why one day someone showed up and murdered most of the people in their village, or if it would happen again. And obviously were rather afraid about going back to where these events occurred. So that's Moiwana Village. Moiwana Village established that precedent that Maroons, at least Suriname Maroons, are tribal peoples and hence have the same rights as Indigenous peoples, at least in international law. That then led to the Saramaka case. And I have to be honest, we used various things in Moiwana as a way of trying to shortcut what we knew was coming in Saramaka a few years later, right? So some of the arguments in Moiwana were prospective, thinking about the next case that was coming, which was the Saramaka case. The Saramaka case was decided in 2007. Much more complicated than the other ones. As the movie told you, involved, I actually count 70 communities. I'm not sure why they're saying 60. So there were 70 up and down the Suriname River, which at that time there wasn't a paved road to get there. So it was a lot of fun driving down and then taking a boat for X number of hours. And they had about 100 and something meetings and had to create new words in their language to explain what international law is, for instance, to explain what the Inter-American Commission is. We had to come up with a whole slew of new terms just to even explain what these different options might be. And that took 3 years of talking about it, which didn't seem like a very good idea in my opinion. But anyway, it was very important, I think, that the Saramaka themselves were deciding what happened there, and their internal cohesion over the years that it took to decide that case, I think, was very much set in those meetings, and they very much stuck behind it, even though the government of the time really came after them and tried to intimidate them to reject the case, or to reject their lawyers, or to reject their leaders, or reject pretty much anything that might help the government, basically, right? It was prompted by two things. One, a slew of logging concessions that had been issued to Chinese logging companies, and a slew of gold mining concessions that were issued, even though to this day we don't really know who they were issued to. No one operated the gold mining concessions, even though they were there. But the logging concessions for sure were wreaking havoc in a large chunk of Saramaka territory. The woman in the movie, Sylvie Ajako, she was the first person to report that they'd basically built a road over her farm. And as a Saramaka woman, not having a farm essentially means you're a useless burden on the community, and it very much undermines her status and her rights within the community not to be seen as contributing. So there's was a big gender dimension that came up initially in that discussion that frankly got lost as the case was processed later on. Although I suppose it could have been argued better than it was. But so there were other issues in there that could have been dealt with that weren't dealt with, including the ongoing effects of the Saramaka losing about 50% of their territory to a hydroelectric dam that was built in the 1960s. If you read the judgment of the court, we tried to bring in evidence and violations related to that evidence in the court hearing, and the court basically said, no, you can't do that now. Should have done it earlier, which we didn't do for a lot of reasons, which I can explain if you really want to know them. So the case essentially argued that Suriname was violating the right to property of the Saramaka, since the Saramaka owned their territory since sometime in the 18th century, including as acknowledged in the treaty with the Dutch that the Saramaka considered and still consider a sacred foundational instrument, consecrated with a blood oath that no one can violate under any circumstance without severe repercussions, even in the afterlife. So those treaties were very important to them, which ran us into the problem of Alabutu, with the court basically saying we weren't going to deal with those treaties. So the arguments presented were really more grounded in Inter-American jurisprudence as supplemented by the jurisprudence of various United Nations treaty bodies, Committee on the Elimination of Racial Discrimination being an important one, but not the only one. So right to property, the right to judicial remedies, and the right to legal personality. I'll come back to that one in a minute. Basically, under Surinamese law, to this day, and I say that with great sadness, to this day, the Saramaka have no rights to their land. Their land is considered unencumbered state lands that the state may do whatever it wishes with at any time, irrespective of whether the Saramaka are there or not, and without even consulting them. That would include logging, mining, dams, bauxite mining, gold mining, oil palm, lots of different things, right? The argument related to juridical personality came from two places. One is the Saramaka as a collective are not recognized as a legal person within Suriname's legal system. Therefore, they're incapable of holding or enforcing rights under domestic law, even though they are recognized as individuals with individual personality. They're not recognized as having collective personality. So the court did a very interesting thing here, and in fact, to me, is actually one of the major accomplishments in that case, is the court read a set of rights together, one of which is not even in the American Convention, and came up with something that, to me, as someone who's worked on these things for many, many years, is very logical. To others is kind of scary in some ways. So it basically read together that the Saramaka own their territory, both as a function, excuse me, both as a function of property rights, but also as a function of the right to self-determination. And as a self-determining people, the Saramaka also had a right to collective legal personality as a people, and the state was obligated to recognize their collective rights within its domestic law and provide remedies by which they could enforce those collective rights as a people, as a collective entity. Self-determination also meant that property rights became something considerably more than they might otherwise have been, insofar as the court said reading these two rights together results in a right of the Saramaka to exercise effective control over their territory through their own traditional authorities in accordance with their own customary laws and traditions, right? So as someone who has worked on Indigenous people's rights for many, many years, that's essentially the key demand of all Indigenous people all over the world. They wish to be self-determining people who have a certain degree of autonomy and effective control over their territory, because their territory is the basis for their survival, present and future generations, as well as complying with their obligations to ancestors in many cases as well, right? So Saramaka not only upheld that indigenous tribal peoples have a right to self-determination, it also then took that out of the realm of rhetoric and said what that means when we're talking about territorial rights is they have a right to effectively control their territory without external interference. Now, people start going state within a state and all that stuff, right? And that's not what this means. It means that within the state of Suriname, the Saramaka have a certain autonomous zone in which they get to decide what happens in their territory and what happens with their people and what development means to them, how they want their culture to perhaps change, perhaps stay the same, that they have control over their own identity, their own history, their own futures. Does that mean they have nothing to do with the state of Suriname? No, categorically no. And the court said not only are they not a state within a state, that the state is not powerless to do things in their territory. It took an approach that human rights are neither pro nor contra development, but do set certain rules that have to be followed should the state wish to build a dam or mining or logging, et cetera, et cetera. And one of those rules was you have to go talk to them first and see what they think about whether they want to mine or whatever it is in their territory. And under certain circumstances, they have a right to say yes or no to that, irrespective of whether you stick a public interest label on it, irrespective of whether you are claiming to be validly subordinating their property rights, either through eminent domain or whatever it happens to be, because there are some interests that are so fundamental that those interests should prevail if you're balancing one versus the other in context. Particularly if the Saramaka say no. If they say yes, well, then there's a discussion about benefit sharing that needs to take place. There's impact assessments that need to take, et cetera, right? So that's the importance of Saramaka to me, although I think there are other people who find it important for other reasons as well. In fact, I'm always interested to hear why people find it so interesting. I was reading the Caribbean Court of Justice decision in the Maya Leaders Alliance versus the Attorney General Belize case. And the court said that Saramaka was one of the most important cases for the region, which made my smile go from ear to ear, made me very happy. But I also thought, what does that mean in the Caribbean region? It doesn't mean anything in Suriname, because Suriname's basically ignored the judgment completely. Not only that, it's been issuing a whole set of mining concessions in Saramaka territory post the judgment, even though the court said to the government it's illegal to do that. They're doing it anyway, and without consulting with the Saramaka. In fact, their position is we'll ask them what they think after we've already issued the concessions, not before, right? So I think Saramaka's had a big impact in other parts of the world, except sadly in Suriname. So I can say that Suriname has now developed a framework law on the rights of indigenous and tribal peoples, which is going to be debated in its parliament sometime soon, which is hopefully a first step towards rectifying some of these problems. And I stress in that context that indigenous and tribal people in Suriname are 25% of the population. So what we're talking about here is the rights out of 1 of every 4 citizens of Suriname. It's not and even if it were, it wouldn't make any difference, but it's not a tiny proportion of the population, right? The Colombia case is called the Operation Genesis case. It was decided in 2013 by the Inter-American Court. It interestingly doesn't involve Maroons. It involves Afro-descendant collectives who basically left plantations after slavery was abolished and established communities of their own in other parts of Colombia. The difference between that case and the Suriname cases is in Colombia, since in fact the 1960s, the state recognized that those quote unquote Afro-descendant communities had the right to obtain collective titles to the areas they were occupying and using. In some cases, not until sometime in the 20th century. So this was followed up by constitutional provisions that basically said the same thing. So the difference between that case and the Suriname cases were, in Suriname, there was no recognition that Maroons or Indigenous people had any rights whatsoever, unless they were affirmatively granted by the state via titles, which of course the state didn't do, versus Colombia, where the state recognized that those Afro-descendant communities had collective property rights, and it had even gone through the process of regularizing them. So in this case, the people who were forcibly displaced in yet another military operation in Colombia were in fact the holders of a collective property title in the first place, right? It was not Maroons, was not tribal peoples as such, and the court kind of left open the question of whether those Afro-descendant communities who didn't fit that tribal label could also acquire collective property rights via human rights law, irrespective of what domestic law said. I don't know what the answer to that is, other than they kind of suggested they might have gone that way even if they didn't have a title in the first place, right? The most recent case is against Brazil, and Quilombola in particular, who are Maroons. I haven't seen the merits report. All I've seen is the press release, but they basically processed it as if it were a Saramaca-like case. It involves 152 communities who do not have regularized collective property rights, even though technically under Brazilian law they do have a right to it, in fact under the constitution even. So there's two kinds of communities. One, those who are still living there, and those who were displaced by a satellite launching base that was installed in that traditional territory there. The commission recommended that Brazil delimit, demarcate, and title the ancestral lands of those Quilombola, those Maroons, required protections for their cultural identity, their economic systems, customs, beliefs, traditions, and required that they protect the self-determination of those communities as well, using those words expressly. So now, these days, the Saramaka are part of a discussion with the state about the content of a law that hopefully is the first step in recognizing their rights within the laws of Suriname. That will change some 300 years of history in that country. And it is largely because of this case, no matter how frustrating it's been trying to get the judgment enforced in a meaningful way. But yeah, the court has dodged the question of prima facie evidence that Suriname gave huge mining concessions in Saramaka territory since 2011. It's known this, and has delayed and faffed around a great deal about not doing anything about it. Even to the point where the Saramaka started asking, what's the point of talking to them anymore? They don't do anything, right? So yeah, there are a lot of issues there. I would suggest that the history of certain countries probably ought to be taught in a slightly different way, and tolerance levels may go up considerably if history is taught in a better way than it sometimes is. That goes doubly for Indigenous peoples who are basically eradicated from, particularly in the Caribbean. There were Indians, then there weren't, and history started, is how most Caribbean history books go that I've seen, right? And I put a lot of Caribbean legal history books in the same category as well. So what is this tribal peoples all about? Well, I know some people don't like the term. Where I come from in New Zealand, Maori people insist on being called tribal because there are 54 Maori tribes, and the word Maori just means ordinary, as in not like you, right? So there's a big insistence on there are these 54 tribes who all have to be treated equally, and don't lump everybody under a category, particularly with a word that no one ever agreed to in the first place and doesn't mean anything in Maori language other than not like you, right? So it comes from an ILO convention, believe it or not, International Labor Organization Convention, the first iteration of which was adopted in 1957. It was ILO Convention number 107, which had three categories of beneficiaries of the so-called rights in that convention, which were indigenous, tribal, and semi-tribal people. The tribal concepts came almost exclusively from Asia. They were particularly India, Malaysia, to some extent Indonesia, and were put in the ILO Convention on the basis that the term indigenous didn't work well in Asia because, for political reasons, the argument about who was there first was not one anyone particularly wanted to have, even though it misunderstands the notion. So it's really who was first in a particular territory rather than a state. I mean, India is not the same now as it was 50 years ago, as it was 100 years ago, et cetera, right? So you can say that about a lot of other places. So it essentially is included in an international convention because there are people who are just like indigenous people, but there are certain people who don't like to have arguments about who was there first or not. The irony is that these days, that concept of tribal is almost exclusively applied in Latin America and the Caribbean, and not really anywhere else. In fact, there's only one state in Asia that has ratified that convention, and it's Nepal. And Nepal considers 37% of its population to be indigenous, not tribal anyway. And the other one is in Africa, the Central African Republic, which also uses the term indigenous, not tribal. So the only place the term tribal is actually used is Latin America and the Caribbean. And it's part of the reason the court so easily slipped into using it in Moywana. In fact, they barely even justified why they were doing it in Moywana, which we can look at in a minute. The reason they did that is because if you look at Brazil, Colombia, Ecuador, even Peru, they all deal with this notion of tribal peoples under ILO Convention number 169, which is the second iteration of that convention, and has been ratified by almost everyone in Latin America and chunks of Central America as well. It has not been ratified by Suriname, however, and the court explicitly said that. It did one of those funny things judges do when they say, we can't do this, and then they do it anyway. So they basically said, we can't use this because Suriname hasn't ratified it, and then just used it continually throughout the rest of the judgment, which I was perfectly fine with because it helped us. But normally I might have gone, you just said you can't do that. Why are you doing it, right? So what does it actually mean? What are the words? So this is verbatim out of the convention. It's Article 1 if you want to look it up. So Article 1A says this convention applies to A, tribal peoples in independent countries whose social, cultural, and economic conditions distinguish them from other sections of the national community and whose status is regulated wholly or partially by their own customs or traditions or by special laws or regulations, as distinct from B, who are indigenous peoples, who are peoples in independent countries who are regarded as indigenous on account of, these are the key words, their descent from the populations which inhabited the country or geographical region to which the country belongs at the time of conquest or colonization or the establishment of present state boundaries, and who, irrespective of their legal status, retain some or all of their own social, economic, cultural, or political institutions. So the Inter-American system has essentially copied this formula here. So there's two sets of people it will regard as having the same rights, basically. One, tribal peoples, and two, indigenous peoples. And the only distinction between one and the other is priority in time. So to be indigenous, you have to be descended from a population which inhabited the country or a region to which the country belongs at the time of conquest or colonization or the establishment of present state boundaries, right? These definitions are extremely unhelpful, and I really hate talking about them because you can come up with literally hundreds of things that fit or don't fit. And the criteria we haven't mentioned yet, which is the third one, is self-identification as indigenous or tribal. So the convention has another section which basically says that the criteria of self-identification is a fundamental one for determining who the people this convention applies to. So if you self-identify as a tribal people, and there's some objective basis for doing so, they don't really dig around all that much into whether it's true or not, or whether it makes sense or not. I suppose if the state were to argue quite heavily that's not true, they might have to get into that, but I've never seen them do it yet. Even Suriname, where they really didn't like these ideas at all. But their argument was more that Saramaka don't have any rights. We don't care if you like it or not, than whether they were indigenous or tribal. In fact, in Dutch, they referred to Saramaka and other Maroons as tribal peoples pretty much anyway, even before this. So it was something that's part of their experience anyhow, right? So can Maroons in Jamaica be tribal peoples? Yeah, of course, if Maroons in Suriname can, why can't Maroons in Jamaica be tribal peoples also? Do Maroons in Jamaica have to be indigenous in order to have rights? No, you can be indigenous or tribal. In Suriname, if Maroons started calling themselves indigenous, all the indigenous people would get very angry about it or fall on the floor laughing their heads off. And the Maroons wouldn't want to call themselves indigenous because they know what that means and it doesn't mean them, right? So they don't need to. Can you be both indigenous and tribal? If you really want to be, but why? Why would you need to be? Pick one, basically, right? So if you're asserting rights and you believe you fit one of these, pick the one that works best for you. The hardest one to prove here is B. It's not A. Why is B harder to prove? You have to prove you're a descendant of one of the original people of a territory. You don't have to do that to be tribal. All you have to do to be tribal is what? Live in an independent country. Check. Whose social, cultural, economic conditions distinguish them from other sections of the national community. Check. And whose status is regulated wholly or partially by their own customs or traditions, or by special laws or regulations. What you'll actually find out if you get into this jurisprudence a bit more is the key criteria used by the court and the commission really are, do you have a profound collective relationship to a traditional territory? That is by far the most important criteria. And it's why I think the court started getting into, well, what do we do with these Afro-descendants in Colombia who aren't tribal, who aren't indigenous? Oh, well, we'll use Colombian national law. That will get us out of that problem. They already have collective rights under Colombian national law. We don't need to go beyond that. The interesting part would have been, what if they did have to go beyond that because there was no domestic law? What would they decide? Well, I don't know the answer to that. I do know in the case of Maroons, if Maroons self-identify as tribal peoples and you can establish there is an ongoing, deep, profound relationship to traditional territory, you're 99% of the way there to same rights as indigenous peoples. And you don't need to say you're descended from Taino or these ones or those ones or anybody else, right? That's essentially the jurisprudence on tribal peoples versus indigenous peoples. I'll give you an example from the Moiwana case, how they did this, where they really emphasizing these land relationships more than anything else. And if you want to look it up yourself, I think it's paragraph 133. And I quote, this is the court saying this, right? After they've basically dodged the issue of who's tribal or who isn't. They say this: so the Moiwana community members, a Njuka tribal people, possess an all-encompassing relationship to their traditional lands. And their concept of ownership regarding that territory is not centered on the individual, but rather on the community as a whole. Thus, this court's holding with regard to indigenous communities and their communal rights to property under Article 21 of the Convention must also apply to the tribal Moiwana community members. Their traditional occupancy of Moiwana village and its surrounding lands, which has been recognized and respected by neighboring Njuka clans and indigenous communities over the years, should suffice to obtain state recognition of their ownership. Yeah. So that's really where you need to go if you're thinking of a case on behalf of Maroons in Jamaica, right? Is there still, and from what I know that there is, that relationship with traditional territory, that operation of traditional government and customary laws, even if it's not complete, it can be partial. It doesn't have to be complete. It could have been eroded over the years in various ways. Is there some recognition that there is this distinct nature to these societies? And that can be, there's even informal recognition by the state of what do you call them in Jamaica? The colonels, the chiefs, in Suriname, they call them the Gama or the Graman. The paramount leader, basically, the tribal chief. So if you have all of those things and you wish to identify with the term tribal, you have the basis for, in my view, and I'm not telling anyone to do this, so don't say I did, you have the basis for bringing a case if you would want to do that. Again, you don't need to be Indigenous. Tribal works, right? Let me see if I can find one other thing.
No, while you're searching, you found it? Good.
Yeah, no, we don't need to do that. Let's not do that. I would encourage you to read the decision of the commission in this case as well, because they do get a bit more into this in that than the court did. And it's interesting to see the way they kind of think through these things, which wasn't very much, to be honest. They kind of said, okay, tribal works for us. Let's move ahead with that. We're good to go on that one, right? So my own personal feeling, if you don't mind the term, it shortcuts you to a set of rights that you wouldn't otherwise be able to get anywhere near, and makes a lot of sense, particularly for Maroons in certain places. Yep. Another question that someone asked me recently is what to do about Garifuna in Belize, in Honduras, et cetera, et cetera. So the irony here with Garifuna is, with the exception of 2 Anglo-Caribbean countries, they're regarded as indigenous, even though they're obviously not, in Honduras, Nicaragua, and Guatemala. So the cases that have been dealt with by the court involving mostly Garifuna in Honduras have essentially treated them as indigenous peoples and not even got into this question. Belize hasn't quite figured out what to do about this yet, even though they generally, on a policy level, talk about Maya and Garifuna in the same way. But legally they haven't, but then legally they haven't done anything about the Maya yet either. The irony is the one place Garifuna are not considered indigenous is St. Vincent, where they actually came from in the first place, right? So, and there still are Garifuna in St. Vincent today. In fact, I had a long chat with one of them the other day, and they actually have a colonial land title that they're trying to do something with. But so Garifuna, even though they're phenotypically African, their language is actually an Arawak language, which is closely related to Lokono and Wapishana languages spoken in Guyana, Suriname, French Guyana, and parts of Venezuela. But they are only not regarded as indigenous in Belize and St. Vincent, even though Belize, I think, is more of a, they just haven't got around to it yet, more than anything else. But at the same time, the Garifuna in Belize, as far as I know, haven't been filing cases like the Maya did, both at the Inter-American Commission initially and then up to the Caribbean Court of Justice. And they're still working on getting that implemented. And I know there is an ongoing dialogue with the Garifuna about that, partly because they have common boundaries in some of the Maya villages and a couple of the Garifuna villages, right? Just to be clear, ratification of ILO 169 is not relevant. The Inter-American Human Rights system has essentially adopted those, for better or worse, those terms into its own system. So it's irrelevant whether anyone's ratified ILO 169 or not, right? or in fact what ILO 169 says, unless you do live in a country where ILO 169 has been ratified, in which case the court has an annoying tendency of referring to ILO 169 rather than anything else. I wanted to finish off with just kind of some thoughts on, as a practitioner, what type of things need to be thought about if you're going to be thinking about litigating such issues. And again, I'm not telling anybody to do that. It was difficult for people in Suriname to actually challenge the state. It was seen as sort of cutting off a fundamental relationship that was important to them, that they had to directly challenge the state. It was psychologically quite difficult for them. And that discrimination that we were talking about before is very real and has very real consequences, not just in public officials saying stupid things, but the level of education in Saramaka communities is essentially up to year 4. And if you get any more than that, it means you somehow got lucky somehow. So it's improved recently, but there's an entire 2 or 3 generation of people. A lot of them can't read and write. A lot of them don't speak the national language. They don't even speak the lingua franca in Suriname. They speak their own. Saramaka is a Portuguese Creole. It's not the English-based Creole that is the lingua franca in Suriname. So it's the barriers are very real and very present for them in a lot of different ways. And the notion of going to court in Suriname was such a strange idea to them. They didn't even have words for it. They had to make up new words to explain how to go to court about something, right? As a pragmatic thing, and again, I'm from New Zealand, so tribal for me is quite a natural term. But I know from friends in Peru, they hate it and they consider it derogatory and demeaning, et cetera, et cetera. As a pragmatic approach, and this doesn't mean you have to use it in everyday life or put it on flags or anything, but in terms of securing rights in a system where the term tribal means something and is a shortcut to those rights, it's almost not helpful to not use it in some ways. At least that's my opinion, right? Whether anyone in Jamaica wants to be called that or not is something else, or Belize or wherever. You call yourselves whatever you like. The Saramaka say, well, we're Saramaka. Stop calling us Saramaka. There's no R in our name. Why did the court put an R in our name? It's Saramaka, not Saramaka. What's wrong with you people? You can't even spell properly, right? So there's a whole range of issues around these names and the like, but don't mix up names with terms of art that are potentially very helpful legally. It doesn't mean everyone needs to get it tattooed on them after they win the case or anything. It just means it's the keys to get in where you need to go. I do think that the discrimination issues need more airing legally than they get at times. It's always been sort of manifestly obvious to me that denying that Indigenous peoples or tribal peoples have rights to their lands where they've lived maybe 10,000 years in some cases, simply because someone showed up on a boat 400 years ago and decided otherwise. I've never understood how that's not considered discriminatory on its face. Yet I've had conversations with judges in lots of different places who tell me that's not discriminatory. And I think they say, well, everyone else is treated the same way. And I say, well, everyone else doesn't have the same rights that they have. So you're essentially negating their rights by saying they all have to be treated the same as everyone else who doesn't have those rights in the first place. How is that not discrimination? The decision of the commission in the Saramaka case did get into those issues. And I think they're also relevant if you're talking about Jamaica or other places. You cannot simply say a set of people don't have their internationally guaranteed rights because you don't happen to like them. I can think of nothing more discriminatory than that. It would be the same as the state saying, well, we don't agree you're tribal peoples and therefore you don't have any rights. Well, again, I've worked in a lot of countries and that's one of the oldest tricks that governments use is they just deny people's rights by defining them as something else, right? There was an interesting discussion in Trinidad recently about whether the indigenous people in Trinidad should be recognized as indigenous or not. And they were accused of being discriminatory for asking that their rights were respected by other people in Trinidad whose rights are already respected under the national legal system. The only ones who are not are the indigenous people. And it's the same in Suriname, the same in Guyana as well, to some extent, although to a lesser extent than others, right? You can be a citizen of a country and have different rights to other people in that country. There has never been any doubt about that. In Canada, they call it citizenship plus. So Aboriginal peoples in Canada have the same rights as all other Canadian citizens. Clearly, they're Canadian citizens. They should have the same rights, no? But they also have rights that attach to their status as Indigenous people as well. So that's the principle that applies in any country where you have Indigenous peoples or tribal peoples or minorities. Minorities have certain rights that majorities don't have. Children have certain rights adults don't have. Women have certain rights men don't have, and et cetera, et cetera. There are these categories in law, whether you like it or not, whether your government likes it or not, that do require that certain groups, in this case, peoples, have certain rights that the state is obligated to recognize, respect, and protect. Unfortunately, in a lot of the Caribbean, seems to be a strange idea, and it's not just in the Caribbean, but it seems to be stronger in parts of the Caribbean, particularly those that suffer from the legacy of the British. It's something that really needs to be dealt with. I've read the case that you're referring to, this Manor case, and much is made of that case, but there's a slew of cases from that time period all around the world which said the same thing about Indigenous peoples. Canada, the first case that opened the door to Indigenous peoples having rights to their lands, was not until 1973. Australia, 1992. New Zealand, 1987. Well, Belize, depending on who you ask, was either 2007, 2010, or 2015. Guyana's still working this one out. They haven't even got to that point yet. Suriname still hasn't worked it out. Although if this law goes through, they will finally deal with that issue, right? So in terms of strategic litigation, the main question really is, are there any remedies, taking Jamaica as an example, are there any remedies in Jamaica that Maroons could use to assert their rights? I don't know the answer to that. There's others who would know much better than I do, but that's where I always start. Are there any remedies? Well, the remedies would have to correspond to the rights that the Maroons wish to assert. And if they're collective ownership of traditional territory, if they are self-determination within the framework of the Jamaican state and autonomy and self-government, would you be able to litigate that with any chance of success? I don't know the answer to that one. I know what the answer to that is in Suriname, no. In fact, the court would tell you to go away. You don't have any standing to be here because I don't know who you are. That's clearly not the case in Jamaica. Now, if you're thinking about bringing a case, does it make sense to try and jump out of the domestic system into the international system and then use the international system as evidence in national law of what the state's human rights obligations might be? I don't know, maybe. Do you have to go to the Inter-American system to do that? Because if you go there, you're going to be there for a long, long time. So does it make any sense to do that? Well, maybe, but it makes more sense to go to the UN. Jamaica has to report periodically to all of those UN treaty bodies. In fact, yesterday I looked to see if they've said anything about Maroons, and 3 of them have. So you've got confirmation from 3 UN treaty bodies already that Maroons, in one case, are tribal people. In another case, have certain rights that are not being respected by the Jamaican government. And frankly, I don't remember what the other one said. CERD was one, and the Committee on Economic, Social, and Cultural Rights was the other. The Human Rights Committee was a third one. And the Committee on the Rights of the Child said something, but in that waffly kind of way, they talk about stuff, right? Can you do this with CERD? Yeah. Do you have to wait till Jamaica reports? No. If Jamaica's reporting, even better, but there's this wonderful thing at CERD called the Early Warning and Urgent Action Procedure, which we use all the time. And so 2 or 3 times a year, you can basically send in a glorified letter to CERD, arguing that there's something urgent and irreparable harm if you don't say something about it. And they usually do, however far-fetched it is. And I'm not suggesting sending them anything far-fetched, but they've stretched the definition of irreparable harm sometimes to the point of breaking it. But very nice. If you've got a vice chair there, who I will not get in any problems with this, but you have a very easy way of getting a confirmation from a UN treaty body that there are tribal peoples in Jamaica, Maroons in Jamaica, Afro-descendants in Jamaica, whatever term you want to use, and that they have certain rights and the Jamaican government is not respecting those rights. Can you use that as evidence when you go to the Inter-American system if you're planning on being there for a while? Yeah. Not only that, I would urge anyone who is thinking of doing that to do exactly that. It's what I call playing ping pong. So I take what one of these bodies says and use it in another one, use what they say in another place. And because the Inter-American system takes so long, you can generally get 4 or 5 years worth of stuff out of UN treaty bodies, UN special procedures, or other things that essentially, either on a factual level or the level of legal argumentation, confirm what it is you're arguing in your cases or in your case, right? For me, a case about Maroons in Jamaica, again, I don't know a lot about it, so please take it with a big grain of salt, is a relatively simple proposition, particularly in light of that Brazil case that I was reading about that they just approved. It seems that they don't have any issue with Maroons equals tribal peoples equals same rights as Indigenous peoples. Why are you not doing something about that, dear government, right? So for me, again, your real question is what would you have to do domestically? You're certainly going to need to send something in on paper to the government asking that they do something about it. Normally you have to exhaust judicial remedies, but there are exceptions to that rule, like if there aren't any, which was the case in Suriname. There were, at the time we were thinking about the Saramaka case in Suriname, there were 51 practicing lawyers in the country. We talked to 49 of them, all said, no way are we doing this case. Go away. So we would never have been able to file the case in Suriname simply because no lawyer would have ever taken it. And if we had taken it, we would have lost because it would have been futile. There was no way they could have won. So do you have available remedies in Jamaica? Would those remedies be effective even if you win? Are 2 very important questions you'd need to think about. The rest of it is relatively straightforward as far as I'm concerned. What would you need in terms of evidence? Anything you can get that further substantiates, or if you don't have it, substantiates those relations to traditional territory would be key parts of evidence. And you can do that through community testimony, affidavits. You can do it through expert testimony. Anthropologists sometimes are useful. You can do it through mapping that shows how people occupy and use their territory, where they do X, Y, and Z, where they have spiritual relations to that territory. And if you can do it on a nice map that a 5-year-old can understand, it's generally a good thing. Again, I've had, and I won't mention any names, but I've had quite a bit of trouble at times explaining some of these things to very learned people, and having a map with nice little pictures on it actually made it a great deal easier, right? So don't assume that people will understand what you're talking about. They often will not. So you have to put it together in a way that your average 10-year-old would understand in some cases, right? So if you're able to put that evidence together, you properly assess this domestic remedies issue. The next bit is just waiting it out. So what if you do decide to go that route, I would suggest you start by playing ping pong, getting yourself some decent things from Assert, from the Committee on the Elimination of Racial Discrimination. Committee on Economic, Social, and Cultural Rights is really nice these days. Human Rights Committee is actually getting better than it used to be. Even CEDAW is getting better these days. Do you need to talk about the the UN Declaration on the Rights of Indigenous Peoples? No. In fact, if you do, you're going to get yourself into trouble because people are going to tell you that's not binding. So why would we talk to you about that? Stick with what you've got that's binding and use the declaration as a supplement to what's binding. It's a much easier conversation to have, right? So you go into the Inter-American system. It's all based on the American Convention, which I understand Jamaica is a party to, but it has not accepted the court's jurisdiction. But is there a functional difference between decisions of the court and the commission? In theory, there is. In practice, I'm not sure there is, because governments seem to treat both as if they're recommendations anyway. The Suriname cases are a good example of that. Is it futile? Is it a waste of time? No. And the Saramaka will tell you they're in a fundamentally different position having that judgment of the court than they didn't have it. Now they sit in a room and they have a very different conversation with the government. The government does stuff they don't like. They have a place they can go back to the court and they can complain about it, even if the court has not been, in my opinion, as receptive as it should have been, right? So you have options there if it's something you wish to do in Jamaica. And I wish you as much luck as you may need.
Thanks so much, Fergus. Whole lot in that last bit about potential strategies. And we have leaders from the Taino community, from the Maroon peoples, from the Garifuna communities in Belize. Thank you all. As we wrap up, a word of deep appreciation to you, Fergus, talking to us from St. Lucia, and appreciation to all of my colleagues who joined from the Inter-American Commission, from the Assert Committee, from important key stakeholders in Jamaica that are thinking about rights. The political ombuds was here, judges who joined us from Belize, from the CCJ, many government officials. It's important, Fergus, the importance placed by several lawyers working with the state in Jamaica in being here to be a part of the conversation. They gave significant priority to it, to all the leaders and members of various peoples across the Caribbean. Thank you. And thank you, students. Many thanks all. Plenty appreciation.